Then it's before I proceed to introducing my excellent panel, just a few words about this topic that like it's very close to me as well, because in Bulgaria we often say that whoever hasn't been taken to court most probably has not been doing their job properly. Legal pressure has been normalized to such an extent in this country that when the world started talking about SLAPPs or strategic lawsuits against public participation, suddenly we started realizing that we have a problem. That actually it's not just some regular part of the job, but we do have a problem and we deserve better protection, which is not that easy, taking into consideration the costs and lengths of such type of proceedings and the fragile financial situation of almost all the independent media in this country, who are usually the targets of such type of lawsuits. So the fact that today we are here in an international audience talking about SLAPPs is already very good news for journalists in Bulgaria and Europe. The fact that we're talking about SLAPP legislation in Europe, which will soon be adopted and implemented in our countries, is even better news, but we still have a long way to go, as the rich and powerful are usually way ahead of us. But I think the people in this panel are doing their best to answer them. So let's see where we stand now with the participants in my panel. I will start from my left. Lora Mateeva is a legal program coordinator at the Anti-Corruption Fund, like a non-governmental organization here in Bulgaria, which mixes journalism with legal proceedings against high-level corruption. She's an attorney at law, experienced in litigation and consultation in the fields of civil, corporate, and administrative law, member of the Sofia Bar Association, and a certified mediator. Hi, Lora.
Hello. It's a pleasure to be here today.
We're very glad we have you here. Flutura Kusari from the European Center for Press and Media Freedom. She runs the legal program of the organization, which has supported more than 250 journalists facing legal actions to cover their lawsuit fees. We'll talk a bit more about these fees and depending on the different countries. Flutura represents the ECPMF at the European Anti-SLAPP Coalition and case, and is a member of the Anti-SLAPP Experts Committee by the European Commission and the Council of Europe. Hi, Flutura.
Thank you for having me.
Thank you for coming here. Stoyana Georgieva is the editor-in-chief of Mediapool. Since she founded the platform in 2000, I think it's kind of the first news media platform in Bulgaria. Yeah, I'm right. She has strived to build an independent and quality publication. She has participated in various civic projects and initiatives, and has been a jury in many journalistic competitions. Also a target in some of the lawsuits that we're going to talk about, not surprisingly. And then Alexander Kashumov, a human rights lawyer. I would say I don't know what we journalists would do without Alexander Kashumov here in Bulgaria to defend us in court. He has worked in the field of access to information, freedom of expression, privacy, and personal data protection since 1997. He's head of the legal team of the Access to Information Program Foundation in Bulgaria, and in the past 2 decades, he has litigated hundreds of cases before national and international tribunals, including the European Court of Human Rights. He's also author and co-author of 5 books, chapter of books, analysis, and many more. Yeah, I'm really privileged to moderate this panel today. Thanks to the organizers. And so let's start with the discussion, because I'm pretty sure that you guys have also a lot of questions towards our panelists. But first of all, Lora, I know that the Anti-Corruption Fund is doing now a report, a monitoring of the SLAPP problem in Bulgaria. I know that it still hasn't been published, but I'm sure that you will review a little bit of your findings to our audience. Where do we stand today?
Yes, this is right. Within the Anti-Corruption Fund, as Maria already mentioned, we have also identified the importance of the SLAPP problem in Bulgaria, not only in Bulgaria. As we all know, it's been acknowledged as a problem within Europe and the European Union. In Bulgaria, of course, as we know and as it will be discussed later, it's been an issue for many years now, for I would say the last 20, even more than 20 years. We have cases that meet the qualification that qualify as SLAPP, as strategic litigation against public participation. But
maybe you could actually clarify the standards. We have also a lot of many young people in the audience that maybe are not so well informed about this phenomenon. I hope you don't get informed personally, but yeah.
Yes, if I may say it briefly, those are lawsuits that are actually representing abuse of litigation, because the claimants on these lawsuits do not lead the proceedings because they protect their rights, because they use the right to civil protection, to court protection. But the reasons of these lawsuits are to silence critical voices, to make journalists and civil activists and civil organizations to stop them being critical and stop them publishing information that's uncomfortable to the claimants. And the claimants would usually be politicians or powerful persons or corporations or companies. And in some occasions, they might also use the help, the support of the state organs. As we know, in Bulgaria, there are also cases where some specific types of SWAP are actually led by state organs. So this is also not unusual.
So let me just clarify, not just court litigations, but pressure applied by state organs. Could you give an example, maybe?
Well, for example, we've had like a year and a half ago, criminal proceedings started against a journalist and a civil activist from Silistra. He's actually here in the room with us today. And the criminal proceedings were started based, of course, on his active civil position. And it was a really severe case because drugs were put in his car and criminal proceedings were started against him. Fortunately, this case finished, how to say, happily, because all charges were dismissed in the end. But of course, it's a big pressure put on the person to be charged with such serious criminal charges. Normally, SLAPP cases would be led either in criminal courts for defamation, for example, most oftenly, and also in civil proceedings where the claimants would claim that they've suffered damages due to specific publication. So our idea within the fund, within the Anti-Corruption Fund, was to try to analyze the judicial practice on such cases, which is something that's not been done so far. And working on the analysis, we figured out some of the reasons why this was not done before. It happened that Actually, it's not so easy to do that because the judgment is always very concrete on each case if it qualifies as SLAPP or no, because not all, and this needs to be made very, this needs to be said very clear, not all cases and not every case against a journalist or a civil activist is SLAPP. Because there are journalists, of course, that do not meet the journalistic standards and that are woefully taken to court. But
of course, people have the right to defend themselves in court.
Yes, of course. So one main difficulty was to first to gather information about these cases. And another, because you cannot take statistical information on such cases. Nobody gathers such information. For example, if you go to criminal courts, you might get all the cases that are led against journalists, but as I said, those are not all SLAPP cases. And if we go to civil proceedings, to the civil court, you cannot at all pick the SLAPP cases just by statistic information because they're qualified under legal provision that gathers a very large and big variety of cases that have nothing to do with cases against journalists. So we're still working on analyzing the cases. We're talking with a lot of journalists that are being subject, defendants to such cases, or know other colleagues that have been taken as defendants on such cases. And we're trying to get as many cases as practically possible and to analyze them so that we really take all those that qualify as SLAPPs.
But and probably your findings will then serve also to the Bulgarian legislators when the Bulgarian state will start implementing the future European legislation. Sounds complicated, but it's very, very important, everything that's happening now. But one more thing, you're a non-governmental organization. We usually relate SLAPPs mostly to journalists, citizen journalists, but non-governmental organizations are also often subject to such type of pressure. And from what I heard, you're actually the Anti-Corruption Fund as well has its own SLAPP.
Yes, this is true. Actually, we can say we have at least two such cases. One is the claimant is a prosecutor that's taken us to court due to privacy protection infringement, he says, and this is because we published prosecution decree as a whole, as it is, including with his signature. So he states that this was infringement and the publication of a signature, yes, it's an official act and actually it has requisites by law. So if we don't publish the signature, it actually doesn't qualify. I might have written it on my own computer. But this case is still pending, and we have another case where the claimant is a politician. He used to be a member of parliament for many years. He used to be a counselor on anti-corruption issues to former Prime Minister Borisov. He's now a municipal advisor, member of the council of the municipality in Sandanski, and he's taking us to court for...
I'm really tempted to ask who is he.
Yeah, it's the name is... Yes, he's Yana Yanev, and it has something to do... I mean, the reason for him taking us to court is for our investigations, which was based on tapes, where he talks a lot and provides his own vision on how the anti-corruption institutions work in Bulgaria. and who's related to who, and who is actually taking decisions within the specialized prosecution mainly, and within the specialized judiciary. That was actually closed down this year, very, very recently, due to inefficiency, actually. So he's claiming in court that those were his own personal conversations, that we were not supposed to tape him and publish them. And also he claims that we owe him remuneration in his capacity as an actor. In the same time, he claims damages.
Good sense of humor.
Yes, well, in the same time, he claims damages for taking his personal life public, and for taking part in our movie, because actually those tapes were part of short audiovisual products that we produce and distribute. This case is also pending, and it will go to second instance. We won on the first instance. So now, but he's appealing the decision. So now we're expecting the next sessions and going to the second instance. Hopefully, the next court would be, I would say, wise as the first one, but we'll see.
Yeah, this is actually one of the characteristics of these lawsuits, that very often the claimants know that they're not gonna, they have very low chances to win, even in judiciary systems that have certain troubles, such as the Bulgarian one, but the whole pressure and the whole process that takes years, of course, is problematic for journalists and organizations. And as you can see, even an organization full of legal experts can be taken to court with such claims. But now I will move to Stoyana, as we already mentioned, as an editor-in-chief of an independent media in Bulgaria. You have something to say about it, and you have some news to share with us as well.
Yes, we will share together with Mr. Kashumov our lawsuit. Maybe it will be case study, and
it is already.
It is already case study, and okay, I will describe briefly for our foreign guests the case. Mr. Svetlin Mikhailov, former president of Sofia City Court and a candidate for its president in 2018, launched a civil defamation case for defamation, claiming that he was affected by few articles published in Mediapool at the time of the pre-election campaign. He started the case against the InfoSpace Foundation, which is the publisher of Mediapool, against the editor-in-chief, which is me, and also against the reporter who wrote the articles, Boris Mitov. Mikhailov claimed damages in amount of 50,000 Bulgarian leva and asked for collateral of his claim. And court issued an injunction, finding that the claim well-founded, and as a result, an enforcement judge froze bank account of 3 respondents of amount of 50,000 leva each. After a year and a half, and after a request on behalf of our representative, Mr. Kashumov, the 2 personal bank accounts of my and of Boris were frozen, defrosted, unblocked, but the 2 banks account of the company stayed frozen till today, and they still will stay. And the amount is approximately 100,000 leva. The articles that Svetlin Mikhailov claims have defamed him and had shaken him so much that he could not resist it to file a lawsuit are actually background materials. They recall all the loud public scandals surrounding the personality of Svetlin Mikhailov through the years. They cited statements by politicians and other public figures, as well as compromising data, information, and articles that have been published in other media, including Mediapool, for years. And over the years, Svetlin Mikhailov has not filed a case against any other media, nor against Mediapool, although the same claims has been released earlier. Mr. Mikhailov did not seek contact with the editorial office of Mediapool to request a right to reply. And there was no doubt for us that the case filed by Mr. Mikhailov is a targeted attack against Mediapool, which is independent media, smaller compared to other publications, but influential, including in the judicial circles, in higher rank administration and decision makers in Bulgaria. This case was a serious blow and pressure for us, and still it is. First, because it created problems with the normal financing of current activity of the publication at the beginning. The account from which the monthly salaries of journalists are paid was seized. Thanks to the fact that the account was fed with additional assets, the work continued. Mediapool does not have its own lawyers, accountants, and financiers to deal with bank issues, with current financial statements, and so on. For all these activities, we have to outsource. The legal defense in this case was initially taken by another lawyer who was later found to be untrustworthy, and we are very glad that it was in time that Mr. Kashumov took up the case and accepted it not only as another legal battle, but also as a mission and cause. And I would say that apart from bank account problems and the other problems, that the real risk for us was if we are convicted, it's about the reputation of the media and the journalists. And finally, I would say that after filing this case, I noticed that the journalists in our newsroom, they are now much more cautious. And when they have to write about people and companies that are reasonably suspected of being involved in bribery practices, abuses, or violations, but who do not hesitate to intimidate with lawsuits and have unlimited financial resources to pursue such cases. My concern is that this healthy caution can sometimes turn into self-censorship. And okay, I will stop here, and maybe later when we have a conversation, I will continue.
I want to pass the floor to Flutura to give a bit more of international context, because it's really not a local problem, but just maybe if Mr. Kashumov wants to add something about this concrete lawsuit and now.
Okay, thank you, Maria.
As from your perspective as a lawyer of Stoyana.
Yes, I can add towards. Indeed, well, this is first of all one of the two most famous lawsuits, SLAPP lawsuits in Bulgaria, which is registered in the international platform, in the European platform, together with the case of Vivo, which is still pending. We don't yet have a...
The 1 million case?
Yes,
another
yes.
one?
Well,
there
yes.
are plenty.
It's a partial claim, but the overall amount is 1 million. But here, we had the first time when so big amount of money was awarded as immaterial damages and by so much public figure, because this judge was not just a former president of the Sofia City Court. It was on a competition to get again this position, and actually the cause for the media coverage was the fact that he's participating, so Mediapool just wanted to remind who that person was. Yeah. As a result, they were convicted in the first instance court to pay, I just counted today, together with the interest, which is obligatorily awarded in these cases, and with costs, it had to be about 110,000 Bulgarian level, which is nearly 60,000 euro. Now it is not completely won, but now the last amount, which was minimized by the appellate court, is 2,000 euro. And they awarded us a lot of costs and all that stuff. So in the end, Mediapool... Yesterday
evening.
Even if the case stops like that, Mediapool will be
success,
okay.
yeah.
But we're considering going to the end because of several important issues. Perhaps I can come back when I'm talking together with other cases. I can briefly say that this was the first time when we had Stoyana being a respondent in the case, not just in her capacity of editor-in-chief, where she's relatively safe because at least the Supreme Court would say that she cannot be held responsible because of the practice. However, this was the first time when she was found responsible in her capacity of real owner of a company which owns media. So the money laundering directive, which some time ago set this issue together with other Council of Europe standards on transparency of media ownership, was turned against media freedom, which is very, very important to keep in mind that different standards on freedom of expression and on other human rights should be understood together and not be tackled one against another. I'm stopping here. I will have then the continuation.
Yeah, of course. In this case, we can see when actually European legislation is used against the interests of journalists and companies. Many of us know that sometimes with GDPR, there are similar problems. Like with the good intention of protection of privacy, unfortunately, sometimes it's used again for lawsuits against journalists. Now I will pass the floor to the legal experts. Mr. Kashumov already had a small contribution. We'll continue, but I wanted to move a little bit out of the Bulgarian context. We have other things going on in this country, not only SLAPPs, but we have plenty of them as well. Flutura Kusari will provide us with a timeline of events throughout Europe that led to the creation of something really good as an answer to these trends that we've been alarming you in the last half an hour. It's a pan-European anti-SLAPP coalition which has achieved remarkable results so far, although it's not that old. I mean, you will tell us a little bit more. And actually moving things in the EU usually takes time. So we can say that they've been quite effective. So Flutura, please.
Thank you. I'll stand there because I have a presentation and it helps to be here. Let me test this. It's working, so okay. Thank you very much for having me. I'm glad we're talking about SLAPPs because strategic lawsuits against public participation have become a very serious threat to freedom of expression, media freedom, rule of law, and democracy. And therefore, they need our attention. Now, strategic lawsuits against public participation, it has already been mentioned, are aggressive and frightening legal claims initiated and pursued with the sole strategic aim of preventing, discouraging, and penalizing public participation. They are used against journalists, activists, civil society organizations, human rights defenders, and others. Now, in a more practical terms for non-lawyers, SLAPPs are lawsuits which are used by business persons, by politicians, priests, public figures, state actors, when they don't like when stories about them are published by journalists. What they do is they hire law firms, ask them to file lawsuits against journalists. It does not matter that they have no basis because the aim is not to win in court. The aim is to drag journalists and activists into courts, to force them to invest money, time, and energy into defending themselves. Now, before they file a lawsuit, something else happens in advance, and that is the intimidation which starts with legal letters. A journalist contacts his subject for a comment, and instead of a reply, he or she gets, what's happening with this?
We hear you perfectly.
Yeah, okay, because I hear a noise, fine. So before they file a lawsuit, when a journalist contacts a subject for a comment, instead of getting a reply, a comment and answer to the questions raised by journalists, they would get very threatening legal letters with very strong legal language, threatening them, asking them not to mention the names of the subjects, not to report about them, and if they do so, then there is a long list of threats what will happen to them, that they will be sued and that they will have to pay damages, etc. Now, as a result of these SLAPPs, those journalists who publish critical stories have to defend their work for years in courts, instead of doing journalism, spending that time to do journalism. And we're very concerned about that. However, we're more concerned about all those stories who were never published because of legal threats. And there are many which have been censored due to legal fears. Now, SLAPPs were being used in Europe for some time, we know this, but they became known in Europe after the assassination of Daphne Caruana Galizia. We discovered that SLAPPs, the cancer of public participation, were secretly spreading by targeting journalists and other public watchdogs in many European countries. And we decided to fight SLAPPs. We created the first European anti-SLAPP movement in Europe. And here I'll provide the timeline of events which led to this movement. It started in 2017 when the most famous and the best investigative Maltese journalist Daphne Caruana Galizia was brutally assassinated by a car bomb. At the time of her assassination, she had 47 active defamation lawsuits against her. Following the tragic development in Malta, members of the European Parliament, especially David Casa, together with other members of the European Parliament, were the first ones to officially address the European Commission, asking the former Vice President of the Commission to propose anti-SLAPP legislation. Casa and other members of the European Parliament then organized an event in Strasbourg to discuss the protection of journalists and reiterated the need for European anti-SLAPP legislation. Now, throughout 2018, Casa was the most vocal member of the European Parliament and one of the first politicians in Europe to push for anti-SLAPP legislation at international level. And I mention him, and I'll mention other politicians, because we can't fight SLAPPs if there are no good politicians willing to help and support journalists and civil society. And we were lucky enough to find some good politicians at European level. Now, meanwhile, a small group of us, friends from Reporters Without Borders, Article 19, Daphne Caruana Galizia Foundation, EFJ, Index on Censorship, CPJ, etc., we were speaking to each other and discussing on a daily basis what can we do. So we had a long list of questions, but absolutely no answers. Are these lawsuits a real problem? Who is suing journalists and activists? What happens to these lawsuits? How many stories have been censored, etc. But the most important question we asked to each other was whether there is anything that we could do at national or international level to address SLAPPs. We decided to ask experts and commissioned the Aberdeen University to provide a legal opinion on whether SLAPPs can be addressed at EU level. Here in the picture, we are at the Aberdeen University premises strategizing how to approach to the European Commission. Now, fast forward a few months, the ECPMF organized an anti-SLAPP expert talk in Brussels. Our colleague and friend Justin Borge from Aberdeen University presented the legal analysis and made it clear that indeed EU has the competence to address SLAPPs. Now, the idea of this event that you see in the picture was to bring together around 20 people in Brussels and to discuss anti-SLAPP legislative solutions. Around 100 attended, which proved that there was interest in Brussels, especially from policymakers, to address SLAPPs. Now, the same small group of people continued to have discussions, but it became clear that we needed to organize ourselves better in order to have impact. Greenpeace International, who already had experience in mobilizing civil society on anti-SLAPP in US, joined us, and since then, there was absolutely nothing to stop us to raise the issue of SLAPPs at European level. This picture was taken in an event organized in Amsterdam by Greenpeace International and University of Amsterdam. Now, to prove that SLAPPs are a problem, we need to document them. The most difficult part was and remains to convince journalists to go public. Lawyers, some of them, tend to advise SLAPPs victims not to go public. This is not always the best advice. And sometimes they do it for personal motives, to keep control over the cases. Matthew Caruana Galizia, the son of Daphne Caruana Galizia, has played a crucial role in documenting SLAPPs. He's our first address every time we need to convince a journalist to allow us to document threats publicly. Cases of SLAPPs are now documented regularly through the Council of Europe platform on safety of journalists and mapping media freedom by IPI, EFJ, Article 19, and other organizations. And by this time, 19th of April, we already had managed to register several cases. This allowed us, for the first time, to dedicate a chapter on SLAPPs on the 2020 annual report of the Council of Europe platform on safety of journalists. And for those who are not familiar with the Council of Europe platform, this is the biggest platform in Europe documenting threats against journalists. We made it clear through a report that SLAPPs pose a serious threat to journalism. And since then, each subsequent report has a chapter on SLAPPs. On 27th of October 2020, Human Rights Commissioner Dunja Mijatović published a legal comment and asked for the first time the Council of Europe to take action and play a role in addressing SLAPPs. She also made a commitment to pay attention to SLAPPs, and she's keeping her promise. Meanwhile, the group of civil society discussing SLAPPs expanded. We're being contacted by activists, journalists, media, civil society organizations, academics who are interested to join the cause. At the same time, we're having regular discussions with the European Commission, asking them what can be done and how we can help. And we, as I mentioned before, we realized that the EU has the competence to address SLAPPs. We decided to commission 3 experts to draft a model anti-SLAPP directive. We're doing the work that the European Commission was supposed to do, and presented this on 1st of December 2020. On 3rd of December, the European Union established an expert group to assist the Commission in the preparation of legislative proposals and policy initiatives called the EU Anti-SLAPP Expert Group, and the group is still active. By 26th of March 2021, we had a good group of organizations and individuals working intensively on anti-SLAPP. We decided to formalize our work and launch the first anti-SLAPP movement in Europe, known as The Case. And if you're not following The Case and ECPMF on Twitter, now is the time. The Council of Europe responded to our call positively. Now, before I speak about the Council of Europe, so the case works is, so it's around 200 individuals now from across Europe. We hold regular meetings. Here, you can't see the details, but this is how the work is organized. We have sub-working groups on advocacy, on legal, on SLAPP contest. We meet regularly. It's very intensive work. And then we plan, strategize, produce documents, advocate before the European institutions, and eventually also get to see some results. Here is a picture from meetings of the case. Now, by 26th of March, we, as I said, we not only launched the case, but we also called on the Council of Europe to issue a recommendation on anti-SLAPP. We wanted a self-standing document to address SLAPPs. On 21st of May last year, we organized the European SLAPP contest. So every year, we award those who make the life of journalists and activists miserable. We decided to award them. We award them with the award Litigation Addict of the Year, Bully Lawyers of the Year, International Bully of the Year, Corporate Bully of the Year, SLAPP Politician of the Year. And we make sure that we name and shame all of them by mentioning with names and surnames internationally. And that hurts them, trust me. It really hurts them. Now here you can see that, yes, in 2 minutes, 1 minute. So here you can see two members of the European Parliament. Now she is the President of the European Parliament. The European Parliament reacted. They issued an ENI report, which is an own initiative report addressing SLAPPs and asking the Commission to react. We had the OSCE reacting with a report. We have the Council of Europe establishing a Council of Europe expert committee. We have organizations putting pressure on Vera Jourova to deliver. We have the European Court of Human Rights for the first time in its history referring to SLAPPs in one of the judgments. And this is for us the biggest achievement in the last years. On 27th of April, the European Commission for the first time proposed an EU anti-SLAPP directive and published a recommendation. These documents provide a set of measures, and I will not go into details, but there is one main thing that we're advocating for: to equip judges to dismiss cases of SLAPPs as soon as possible, so the journalists are not dragged for years into court. And I'll conclude by saying that the way forward is first seeking member states, including Bulgaria, to support the proposed directive, because all member states need to support this. Secondly, we need civil society and journalists to react to SLAPPs, to join forces and to fight them. And without civil society, especially at national level, we can't fight SLAPPs. Thank you for your attention.
Thank you. Yeah, you can see the results when actually people act together. It's really remarkable what you have achieved for just a few years. And now I'm passing the floor to Alexander Kashumov. We started talking about the legal solutions, because I would like to close this discussion by solutions, and speaking from your broad experience. What do you think that this EU legislation would change the rules of the game, and would there still be challenges, especially in countries with vulnerable media environments such as ours? Thank
you, Maria. I think that on one hand, of course, European legislation will make things better, and on the other hand, the battle will not stop there. SLAPPs are a very long story issue, and I think they will not stop soon, because this is the democracy. I mean, people who want to participate, to raise their voice, to criticize politicians and officials are always understood as troublemakers by politicians, businesses, and officials. I'm very happy that today, in this year's anti-SLAPP conference, we have this good news, because last year, in the anti-SLAPP conference in December, which was organized by the European Parliament, we had two bad news. One was the conviction of Mediapool, and the other one was the started case against Bivol. So I hope that we're getting a bit better. I will tell very shortly what are the challenges today in the Bulgarian environment. Remembering that when I personally started, which was more than 20 years ago, the situation was different. It has improved on one hand, and on the other hand, we have new challenges. For example, criminal defamation was a very big problem in the 90s. And it is still a problem, but I'm very happy that now in the Parliament we have a legislative initiative which will change the criminal code in a way that public officials cannot get bigger fines in cases of defamation which was done through criticism against them. This is very important legislation initiative, and it came actually from my first case in Strasbourg, Kasabova, and the other case, Boshkov, against Bulgaria, and after that, a range of other cases, which made the Ministry of Justice to respond to Strasbourg practice. And in the last years, in 2016-17, there was a working group formed in the Ministry of Justice. It was a pity that I was the only NGO representative there, so it was very secretly working. And then Days Minister, Mr. Danil Kirillov, didn't actually want to, well, there were amendments, but there was not initiative. So I'm happy that today, after the initiative, the two last ministers of justice, this is already in the Parliament. Still, however, criminal defamation is a problem, and we have the case of Rosen Bosev, former Capital journalist, which is in Strasbourg, and it will be soon decided. But it's both the issue of criminal defamation and the issue of judicial integrity, because the judge who was subject to his criticism actually didn't withdraw from the case, but confirmed conviction. Then we have the problems with civil defamation today, because the claims and the amounts awarded by courts are speedily increasing in the last years. Just 4 or 5 years ago, the average amount was 5,000 Bulgarian leva of moral damages awarded. Today, they're 10 and more times bigger. This is very concerning and annoying, and I think that we can act either by court practice, which we tried in the Mediapool case. The Supreme Administrative Court said in an interim ruling about the freezed bank accounts that courts should respect the average practice. But we will see whether we can build on this, or we would need a legislative amendment. Then the practice of freezing accounts is very, very annoying. I know that that in other places in Europe it is similar. I think we need either legislative amendment or court practice. some time ago, when we participated with many other NGOs in Europe in an intervention in Strasbourg on Mosley versus UK case, we succeeded to persuade the European Court of Human Rights that a preliminary injunction could amount to a censorship. But unfortunately, it was not about freezing bank accounts and its precedents, so I think we need something like that at the European level. And I'm talking about Bulgarian challenges, but I think there are also European challenges, at least many of them. Then the forum shopping phenomenon, one of those which hopefully will be addressed by the new legislation, EU legislation. We have at least several cases. We have the case of the Maltese lawyer Manuel Delia, which we won in the end of last year, which was started by a Varna businessman here in the Varna court. Then we have other examples of that. For example, the case of Maria Cheresheva a few years ago, which was a case of a very good international investigation, which they did on the origin of the machine gun Coyote, and following its way from Serbia through Bulgaria, Saudi Arabia, and going to Syria to be used by the rebellions. Then perhaps Maria will add something after that to her case, but then the Bulgarian businessman, who is a famous boss of weapons trading.
Be careful.
Yeah.
He claims he's not.
Yeah. So he decided to sue her here, but he didn't sue any of the other authors of the article because he didn't found it realistic to hold them responsible. And last but not least, a recent case. In all these conferences, I am always sharing new cases that have not been made public so far. Bivol, a new case against Bivol, which is a revenge, obviously, coming from their investigation a few years ago, when, as a result of their investigation, a tanker ship was arrested in the sea coast. Now, the boomerang starts from Greece, because someone found that the judgment of the Greek court, which was referred to by and published by Bivol in their article, contained actually personal data of suspects. And in Greece, which is a very rare case in the EU, processing of personal data against the law is a criminal offense. So they started a criminal case, and they delegated to the Bulgarian prosecution, which was very happy to investigate Bivol, because unfortunately for them in Bulgaria there is no criminal responsibility for personal data protection violations. So now they're doing interrogations and all that stuff on behalf of Greek government, not government, but of Greek authorities, using the directives about EU cooperation in criminal justice. And this is a pending case.
When did it start?
It started this year, this summer. So a lot of cases on the GDPR issues, which is still a problem. We have some very big successes, starting from, the whole story started from Zarko Marinov, who is here in the audience, the owner and editor-in-chief of Odzvuk in Smolyan, one of the local media. Their media was fined 9-10 years ago with a very big fine for a local media, and this is about the vulnerability of local media, which will be discussed in the next panel, as I see. And this was 11,000 Bulgarian leva, which was more than 5,000 euro for a local media because of exposing a notary deed in order to prove their allegation, and actually not allegation, but they disclosed corruption. We won the defamation case, but then there was a problem with the GDPR case. It was not GDPR at that time, but personal data protection case. So when GDPR came in force, the Bulgarian Personal Data Protection Commission said, okay, now we are going to do the balance between journalism and personal data protection in the national law. And they said, we will make a list in which cases the journalistic expression could be understood as journalistic, and in all other cases, it is GDPR. It is protected personal data. So we had a very hard public discussion, including in the parliament, for a year and a half. Unfortunately, we couldn't, Access to Information Program, and there were other NGOs and experts as well. We couldn't persuade the parliament, but then fortunately some MPs introduced this case in the Constitutional Court where we presented our analysis and our statement, amicus curiae, and then the Constitutional Court found the provision unconstitutional. After that, the Personal Data Protection Commission improved their practice, including in the case, we don't know yet, but in the case which Lora mentioned, I already went there on the same case because it was the same document, indictment, published by the Anti-Corruption Fund on their website and on the website of Sega newspaper.
Yeah, they republished our
Yes, they republished from the Anti-Corruption Fund. So there were two complaints against the NGO and against the media.
Right.
And we just, I would say, somehow won the case because the Commission said that this is a violation, but there will not be sanctioned because it is a very minor one. Which is good. I sent already to Lora the decision, so we hope that the Commission will follow their own practice.
Well, the problem here with this decision is that they actually identified violation. They said there is a violation because of the signature that was published. And the only reason why they didn't put any sanctions on us or on the newspaper was that we changed later on, after the complaint was filed, we changed the document. Like we published another one without the signature, where the signature was not visible. So that's why they said in this case, because it was already remedied, the violation is not present anymore as to date, then we're not imposing sanctions. And then actually we appealed that in court because this is one of our major tasks to lead really, as Mr. Kashumov does as well, strategic litigations, because here actually we have a problem because the Personal Data Protection Commission thinks that this is a violation. So the next time we decide to publish an official act in its as it is, without any modifications, we would have, or with whoever, journalist or activist, would have a problem again.
Okay, you can see that there are so many interesting cases and details to be discussed, but I would really like to open the floor for a few questions. We have something like 10 minutes. So in case anybody from the audience wants to raise an issue towards our panelists, please, now it's the time to.
Hello, so basically, was the international score the highest that you know in Bulgaria is the amount awarded for damages or punitive damages? Because in America, when you have a case for defamation, usually the punitive damages a couple of times higher.
Well,
yes,
if I may answer and you may.
Lora?
I would say we have completely different legal systems between Bulgaria and the United States. Here, punitive damages are not awarded. So what we have here is the claimant goes to court, normally to the civil court, or having civil claim within the criminal proceedings, and they have to prove they suffered the damages that they claim. But it's not punitive damages.
Yeah.
So the biggest, as far as I know, is the Mediapool was until yesterday.
Yeah, until
but
yesterday.
You may add,
Yeah.
yes, of course.
No, but let me add to this. Indeed, in terms of legal theory, we don't have punitive damages here. In fact, we do, because there is a mandatory legal interest, money interest, which goes every day, for every day which passed from the date of the tort. And this is understood as tort. So, in the case of Mediapool, let me give an example to be very clear. The first publication was made in February 2018. So, I just calculated today, and I found that if this 60,000 moral damages award was confirmed, in addition to it, automatically it is confirmed an additional 30,000 sum up to today. And to the end of the case, which could be summer next year, it will go higher. So this is still a problem, and I would say that, of course, compensations given in American courts are much bigger sometimes for defamation. But let's come back to the income of the people in the two countries and the size of the companies who run media. Right. Because here, especially local media, are sometimes run with an annual amount of, I don't know, you will say perhaps 10,000 euro. This is nothing.
And I would just ask Flutura, because on European level the numbers are different. I know that you have worked with some extreme cases, especially when the cases are brought in front of British courts, which is still a huge problem.
So from the applications that we receive for legal support, the most expensive country in Europe to litigate is London, be that for lawyers' fees, but also for damages. I don't have scientific data, but this is based on these 250 cases. A lot of them are from London, so it's very expensive. To give you an example, if someone is sued in Bulgaria or Serbia, you'd have journalists asking for 1,000 to 3,000 euros to cover lawyers' fees. When this happens in London, they ask for 1 million euros.
Yeah, I just want to thank Flutura for supporting cases in Bulgaria. This is very important. Thank you.
Thank you.
Other questions from the audience? Maybe one or two? Or comments, maybe? Last chance? Okay.
As was said, not every case against a journalist is a SLAPP. In the anti-SLAPP directive of the EU, how is the distinction made?
Flutura,
Yes. So basically, all the instruments that are being proposed or passed, they're looking into an indicative list of indicators which are supposed to help judges, lawyers, and others to identify SLAPPs. And there are a few elements that are mentioned. First is the claimant usually uses its economic advantage to sue journalists. You'd have a very powerful or a millionaire going after a small media outlet. You'd have the cases with little or no merit, and there is this difference is important. Of course, it happens regularly that journalists do mistakes. It happens in every single profession. It happens in journalism, and it will happen. But there are ways to remedy that. It was mentioned that one of the claimants did not contact Mediapool when they wrote a story. So the idea is that you ask for a comment, you ask for an apology, to change, amend an article, or use self-regulatory bodies. So an indication that is a SLAPP is when, let's say, a business person would immediately sue a media outlet for a small mistake and ask millions. That gives you an indication that it's a SLAPP. The request for damages, it was mentioned, as soon as you ask as a claimant 500,000 euros or let's take examples in Bulgaria, 50,000 euros for Mediapool. Then what is the aim? To close down, to shut down the media, or is it to use it as a remedy? Because if someone makes a mistake, of course they have to pay. But asking 50,000 euros, it's a clear message that they want to shut down the media or send a message to others. This is what happens to you if you report about us. And the last indicator that we're looking for is these legal letters that are sent in advance. It happens very often with very strong language. And I'll conclude by saying, of course, there are like very few individuals across Europe which oppose anti-SLAPP legislation because they say it's a matter of access to court. Indeed, everyone who thinks that he or she has been defamed or his or her privacy has been violated, they have the right to go to court. And the proposed directive does not forbid them to go to court. What the proposed directive and the measures do is that as soon as that case reaches the court, then judges should immediately dismiss if it's a case without merit. So it's a very good balance between the right to access information and the obligation of the state to protect journalists.
And if I may add some things about the proposal directive, what you mentioned, this is one of the most important things, the early dismissal, because what we have here and across Europe, of course, we would have like 10 or more open court sessions without any merit, like on ungrounded, on completely ungrounded claims. And this is very burdening for the journalists or for the activists that are the defendants on these cases. So the option for early dismissal is one very important thing that's being proposed now, and hopefully it will go, it will stay in the directive as it is. And of course, on your question how they decide if it qualifies as SLAPP or no, this judgment is always concrete, and it's always the judgment of the judge that's looking at the case. You cannot say in advance, oh, these indicators that they're very, very important, they're helpful, but it's still the judge to decide. And it is very useful to have this early dismissal. The other very important thing is the change of burden of proof that's being proposed in the directive. And this is also a game changer, I would say, because it will really help whenever the activist claims that this is a SLAPP case. Then the claimant is the one to prove in this very early stage that his real reasons for starting this litigation is just exercising his access to justice and standing for their rights, and not censoring and not harassing and not intimidating the defendant.
I hope this made it clear. There would be more and more talks about this directive.
Perhaps something very short.
Just
a
clarification.
It is very important to be kept this distinction, because also today our society, as well as other countries in the region, are also subject to attacks by some groups of media which are actually trying to jeopardize democratic values and are attacking any critical speech, public activists, journalists, and all people who want to bring more democracy, protection of rights, rule of law. So it is important, but it is an important attempt to make at an early stage a distinction between these two types of cases, whether it's designed to stop talking or it's designed to attack criticism.
Thank you for your questions, and thanks to our panelists. As I said, it's really a privilege to sit among people that I can clearly call change makers with their efforts in the field of more fair process for journalists. That was all from us.
Yeah, thank you, Maria, and thank you, panelists.